Good evening, and thank you for joining this live Tenant Farmers Association webinar. I'm Robert Martin, I'm the National Chair, and tonight we'll be discussing common farm partnership pitfalls, a very juicy subject for this evening, with our special speaker, Harry Russell, Associate with Roythornes Solicitors, who are also kindly sponsoring this evening's event. While we're waiting people to join us, for those that you do not know, Roythornes is a national law firm steeped in agriculture. They have 90 years' experience advising landowners and tenants alike. Their lawyers are active in farm tenancy policy groups. They get the bigger picture. So whether it's a succession application under the Agricultural Holdings Act, a new farm business tenancy, a dispute with your landlord, a share farm agreement, or a collaboration natural capital agreement, Roythornes is there to advise and assist. A few quick housekeeping rules before we get into tonight's webinar. This webinar is being recorded, and once edited, it will be available on the TFA YouTube channel, alongside our full video library of past events, short teachings, knowledge shares, and the key news snippets. So if you search for @Tenant Farmers to find us, subscribe so you're notified of any new content. So moving on to this evening's main event, many farm businesses operate through some form of partnership model, most commonly involving family members, ranging from entire informal arrangements to those that are comprehensively demanding. Whatever your circumstances, all of these partnerships will have been governed by the Partnership Act of 1890. In the 135 years since the Act reached the statute books, partnerships have been a breeding ground for disputes at great expense to those involved. Tonight's webinar will help us think about what can go wrong and how a well-framed and providing a framework for resolving them. Our guest speaker tonight first joined us in June of last year, and it's quite enjoyment as a holding, and we're delighted to welcome him back. Harry Russell is an associate in the dispute resolution team at Roythornes Solicitors, advising on complex agricultural and commercial contractual disputes, including agricultural tenancies, landlord and tenant matters, and the partnership disputes involving agribusinesses. His practice regularly involves high court proceedings and private arbitrations, whether pursuing or defending high-value claims or seeking specific relief, such as injunctions. Harry was recently appointed as a recommended solicitor. One recent example of his work includes settling a family partnership dispute involving assets in the region of £70 million, following proactive litigation in both the High Court and arbitration. Tonight, Harry will guide us through the minefield of farm partnerships and the steps that we can take to avoid the most common pitfalls. So, Harry, the floor is yours, and we'll look forward to hearing what you have to say tonight.
Thank you very much, Robert. That's very comprehensive and a very kind beginning to the session. As hopefully people have gathered, and good evening, everyone, my practice is very much when things have gone wrong. So I deal with a range of agricultural matters, and very frequently, as you probably know yourselves, that often involves partnerships, it often involves tenancies. And so as far as what I'm going to talk to you today about, I'm going to talk generally about partnerships and how they might go wrong, just to set the scene. We'll think a little bit about how agricultural tenancies might then interplay with those points, and how you might want to plan and avoid those issues before we wrap it all up. But a couple of the key takeaways before I get on. By definition, talking about things going wrong is going to make partnerships sound it's going to be quite pessimistic, but I don't want you to think that you hear the word partnership, you cut and run. It's a business structure which can work for you. It's just you need to think carefully about what you want and what you need, and I'll talk about some of the summaries as I go. And the other point that I just want to make sure you think about throughout is that you just need to plan, and you need to think about what works for you and the other partners and your family, whoever might be involved. And don't think in isolation, and don't sort it once and then forget it evermore. But if we get started then, if we start talking about what actually a partnership is, most of you will know this is very common in the agricultural world. It's one of several different ways of setting up a business. You might have a sole trader, if it's just one of you. You might have a limited company, or some other varieties of those. But most commonly in the agricultural world, at least in my experience, it's been a general partnership. And as Robert told you in the introduction, those are covered under the Partnership Act 1890. And despite the fact that we've had that around for over 130 years, the actual partners and the professional advisors and everyone in between is still getting them wrong, and there's still issues developing. So it is as important as ever that you get it right and you think about how this can work for you. So just a brief legal definition, I'm afraid, and I think this is the only one I've got for you. When you get to what a partnership is, it's two or more individuals, partners, working together to carry on a business with a view to making profit. Now, it does happen sometimes that you don't mean to enter into a partnership, and there's many cases about that alone. But you will form a partnership if you tick that box. You don't have to actually make a profit, but you have to be trying to effectively make money. And there are good reasons to have a partnership. Before I get into the pessimism, it's a structure that gives you a great deal of flexibility in a business. It can give you and the other partners a clear structure for how you want to own the assets in terms of the capital, split the profits, and it splits the duties if you want to set all that out. There's essentially a great amount of flexibility, and through all of that, you don't necessarily have to deal with company's house or certain of the more corporate aspects, which I tell you can be a real pain. So where can things go wrong then? Where are the pitfalls? What happens in general partnerships that might happen? If we go to the next slide, please. There's a few examples I've listed here. One of the big questions that I have every single time a matter of a partnership comes onto my desk is, what's the agreement? Many of you will know this already. Some of you might be coming fresh to this, but you can have an unwritten partnership. You don't have to have a partnership deed in a grand document. It can be as informal as just a conversation and two or more people working together. And the problem with not writing everything down or not discussing it properly and having a clear set of terms is that you can be caught out by effectively the default position. You can have a lot of uncertainty, a lot of lack of clarity of what the partnership does, what the duties are, what the assets are. And when things go well, that might not be a problem. And that will probably be the case for most partnerships. But when things begin to fall apart, and that might be because partners have fallen out, might be because partner has died or been made bankrupt, things can go very wrong. And so it is sensible generally to have a good idea of what the terms of your business are. And ultimately, that is going to be enshrined in a partnership agreement, which covers the point as best you can. If you don't have those, you're going to have smart Alex like me pressing you for what the actual terms are, and trying to cause problems. We'll be thinking about, what the actual assets are, what are the terms of the contract between the partners, how does it all work together? And if you don't answer those questions properly, or if you don't have the information, you'll find yourself in a scenario where you might have misunderstandings with the fellow partners, you might have misunderstandings with HMRC or otherwise, and that can lead to consequences. If we think about a scenario where the partners have 20, 30 years ago set up the partnership business, maybe they then did a deed, maybe they then wrote it all down, or maybe they didn't. But in the 30 years since, things have probably changed. New assets might have been acquired. Don't necessarily know on the face of it whether they will be partnership assets or not, and that is important, and I'll explain why in a bit. But the point is, you need to review it, otherwise these uncertainties come back to bite you. Taking the assets point, for instance, it's quite common for assets to be acquired on behalf of the partnership without the partners necessarily intending it. And that's often because partners might use, for instance, the business account to buy assets, or to, maybe they've sold a bunch of crop or some livestock, and they're using those proceeds to then purchase a new bit of land, or maybe they're using it to put a new structure on the land. And it could well be that even if that's not the actual intention, that then becomes a part of the partnership. And then if you get in a scenario where the worst case happens and the partnership has to be dissolved and wound up, then the default position is that everything will probably get sold. You can maybe get around that, but that is the default position. And if everything gets sold, you might suddenly find that land or property or assets that you thought were yours were actually being held for the partnership. And that would mean they have to be sold. And that can be a real shock to some people. And all of this arises particularly when you have partners that fall out. You might have a scenario where families have gone on for years, fall out, things change. You might be best of friends one day, but a week later, something could happen. And it's not always sensible to just assume that the worst won't happen. So do have a think about how this can be dealt with, and we'll cover that. Tax consequences. I'm not a tax lawyer. I won't begin to advise you on the possible tax consequences. Otherwise, I'll get in trouble. But just as an example of how things might go wrong, if you bring an asset into the partnership, there will potentially be a taxable event there, because you are effectively conducting a transfer. It's something people often don't realise. There are heaps of tax considerations with partnerships, as there are with companies, as there are with sole trader businesses. But there are nuances to partnership, and it is important that you speak to accountants or tax lawyers as you go to make sure you're not setting yourself up for an unfortunate event. And then succession. This is a major one. If a partnership hasn't planned properly, the partners haven't planned for what happens when a partner comes or goes from the partnership, it can cause real problems. The default position, when you haven't got any terms agreed for it, will be to refer back to the 1890 Partnership Act, and also any case law which might influence that. And that could be, for instance, in the default, that if a partner dies and you haven't agreed otherwise, the partnership will just end. It will just result in a dissolution, and technically that will then trigger the winding up, which will then eventually lead to a sale of all the assets if the partners can't agree how to deal with things otherwise. So that's potentially pretty severe. And in the same way, if you haven't got written terms dealing with it, if it's just a general partnership, any of the partners can serve notice at any point to just end the partnership, and that's that. That's just done. So you do need to think about what the partners want to happen in the event of wanting to bring new people in, people leaving, retiring, dying, being made bankrupt, all points that will have an effect on the future business. And these things happen, they happen unexpectedly. And I am going to go a bit on my soapbox here, I'm afraid, with succession, because it is a bit of a bugbear of mine. I think people in this country, and particularly in the agricultural world, do not talk about the difficult topics of death and succession enough. And it causes problems. It keeps me very busy, so in many respects I should be thankful for it. But it's sad every time. If we talk about it openly, maybe it will go a bit better, and that goes hand in hand with the general planning. And the point I would also make about agricultural partnerships is that there's frequent issues that are compounded by the lack of available cash compared with sizable assets. If, for instance, you do end up and down one of these pitfalls, and you are in a scenario where you're going to have to divide up the business assets, you might find that it's dealing with valuable tenancies, valuable pieces of land, expensive pieces of kit or otherwise. It might not be enough cash to simply buy someone out. And if you can't buy someone out, that increases the chance you might have to go down the worst route of selling everything and incurring a whole heap of tax. All the more reason, I think, to make sure that you've planned properly in advance. But if we go to the next slide then, because this is a chat for the Tenant Farmers Association, we need to think about tenancies and how it interplays with those points. One of the main thoughts that should be running through your head whenever there is a tenancy in a partnership running hand in hand is who is doing what with the land, with the business, how's it being used, who's paying for things, how does it all work together? Because those can be pretty critical points. With the tenancy terms, now, you might have specific points in the tenancy agreement, and obviously, as many of you know, these might be very old tenancies. They They could also be quite new, but they might restrict certain things on the land that the partnership wants to do. I haven't seen instances where necessarily a tenancy will prohibit entirely an agricultural business being ran there, but there will be considerations. Maybe you want to set up some new structures on the land for the partnership business to expand or develop. Maybe that's prohibited by the terms of the tenancy. Maybe the landlord's reserved a number of rights to use the land in particular ways. Maybe they want to keep it keep all the sporting rights, for instance. And if you wanted to start a livestock business, whereas the landlord wants to come onto your land for every weekend for 6 months and fire lots of shotguns there, that could be a problem with setting the livestock off. So just think about how the tenancy terms might play with the partnership terms. Because effectively they're two contracts and they need to be considered together. Another point is, are the partners the same people as the tenants? There's no requirement for that. You might have one tenant and say 4 or 5 partners, but the partners might be entirely dependent on that tenancy because that's the only land the business has available for the continued operations of it. In those scenarios, you need to think, well, what does that one person have to do to make sure the other 4 or 5 are protected? You might want to build into your partnership agreement the restrictions that prevent them from, for instance, just serving notice to end the tenancy or going away and negotiating a surrender. Is the tenancy a partnership asset? This can be big. Partnership assets, as you may or may not know, are held by the partners on trust for the partnership. That essentially means that if you've got a piece of land, it's in the legal name of 1 or 2 people, but there's 4 partners and they're all entitled to an equal share of the capital. What actually means is those 2 legal owners don't necessarily get on the end of the partnership that bit of land. They will get a chunk of the value of the land in the same way that the other partners would if they all share the same equitable share. That might mean, and does mean, misunderstandings can arise because you might have a number of partners that come together with their own bits of land, put it all in partnership together, not think too much about it and just think, well, I've lived in this farmhouse for 20 years. I'm still going to live in this farmhouse during the course of the partnership, except the partnership's going to pay the bills and deal with the maintenance, this, that, and the other. But then, for whatever reason, the partners decide they're going to end their business and go their separate ways, and they'll just take their land back out. Won't necessarily be the case, because if you get to a scenario where there is a winding up and a dissolution of the business, what happens is the partners are entitled to a share of the proceeds once those assets have effectively been liquidated, so sold. Obviously, you can agree otherwise, but don't trick yourself into thinking that you've got an explicit right to a particular asset. When that comes to the tenancy, you're complicating things so much more because many, if not the majority of tenancies, will have a prohibition on assignment and alienation generally, which can mean that you can't necessarily sell the tenancy. You can't deal with it other than giving it up or maybe negotiating surrender. So how will that work? How does that work for the business? What if the tenancy is a partnership asset, but the tenant all of a sudden wants to give up the ghost and go elsewhere? It might be that they negotiate a compensation surrender, as often happens, but then do they need to share that compensation with the other partners? They probably do if it's a partnership asset. But again, it will depend on the terms of the partnership agreement, such as it may be, and how the partners have decided to deal with such a point. So if you've got a tenancy, you do need to ponder these points. And I would urge a healthy dose of caution about bringing a tenancy into the partnership as an actual asset, because it can really complicate things, given that when you're dealing with something like an Agricultural Holdings Act tenancy, you can't really sell it. What happens if the tenancy ends? Well, those are a couple of examples of what might happen there. But also, don't forget that there's potential dilapidations bill. So at the end of a tenancy, general stance is that you'll need to bring the tenancy back up to how it was at the start, and that can be a healthy cost to the tenant. If it's a partnership asset, it's probably the case that the partnership is on the hook for paying for that, or at least refunding the tenant, in the same way that if the tenant's been paying rents during the course of the tenancy, but the partnership's getting all the benefit of the land, the tenant's effectively making a payment on behalf of the partnership. So they're probably entitled to that to be accounted for. But don't forget as well that tenants can serve notice to end it. So you might want to have a partnership agreement that restricts the tenant's right to bring an end to the tenancy or deal with it in a certain way that might upset the other partners. I have skipped over succession planning, so I'll go back to that briefly. Don't miss the opportunity. This isn't really a pitfall, but don't miss the opportunity to use a partnership in the vein of succession planning for the tenancy. So if there's succession remaining on the tenancy, you can, for instance, use the role within a partnership to help support a suitability test for an Agricultural Holdings Act tenancy succession. It can give you some good management experience. It can be really good evidence for the financial suitability, as well as obviously the eligibility in terms of deriving your livelihood from the holding. So it can be a real boon there. That's not really a pitfall. Just thought I'd throw that in there because it's quite a helpful bit. In terms of the tenancy and the partnership, if the partnership ends, well, we're going back to this partnership asset point. There could be a whole heap of considerations that flow from the partnership ending and having to figure out who's entitled to what of the assets. If the tenancy is an asset, that can really distort things because tenancies can be worth a lot of money. And some point that does get missed. But if we go on to the next slide, please, we'll have a think about how you can avoid these things. And I'm afraid there's no real shortcut to this. In my view, you need to really put the time in. It's hard graft, but you need to think about what works for you, what works for the other partners, taking into account all of the points that I've mentioned as far as they may be relevant to you, and indeed others, depending on the peculiarities of your situation. And then you need to take that, decide from that what you actually want to achieve, and plan accordingly. And it might be that you don't need chapter and verse necessarily. It might be that you do need quite a complicated agreement. Often simplicity works best, but you still want to deal with some of the critical points which can find partnerships getting unstuck, such as dealing with what happens when a partner comes or goes from the partnership business, what happens when someone dies, what the assets actually are, keeping a schedule, for instance, of what they are. And very importantly, if you can put that into a clear written agreement, you will make your life a great deal easier in the future. Never forget as well that if there's the unfortunate situation where you pass away, your successors need to figure out what your share of a partnership might have been. If there isn't a clear document that helps inform that process, or indeed the extent of records, the accounts, the invoices, receipts, what have you, it can be a great deal harder for them to figure out what's going on there. And the other point that I really do need to stress is it's not just a one and done situation. You need to review the situation. Things change. People will gradually get older. The next generation might want to come in. All of a sudden, what worked 20 years ago might not work for the next 5 years. One of the partners might be wanting to, for instance, bring a child into the arrangement. The other partners might think, well, actually, I'm not sure I want to go into business with them. I want to stay in business with the person who wants to retire. It might be that you can't figure that out. It might be that you can. But it is important to think about, does the partnership agreement, such as it may be, still work for you and your needs? And particularly when there is an agricultural tenancy in the works here, and particularly on the question of succession. If there's a potential change to the tenant of the agricultural tenancy, the original tenant might have been a partner. Is the new tenant? They might not have been brought into the partnership yet. Maybe they should be. Maybe that's an opportunity for a refresh of the agreement, so you can make sure that their capital share or their profit share reflects what's reasonable and what the partners want to do. And then finally, as I've touched on already, keep the records if you can, please. It's all too easy in the agricultural world to just say, well, I've known him for years. We can have a chat over the kitchen table, cup of tea, and that's that. But then if you need to read that back and figure out what actually happened 15, 20 years ago when you had that conversation, very easy for misunderstandings to arise. And if misunderstandings arise, you can find yourself in sticky water. You don't want to get into a dispute with somebody that you've always got on well with and had a successful business with. So if you have it written down instead, it will make your life easier in the unlikely event that things go wrong. In summary then, on the next slide, do want to stress it's not all doom and gloom. Partnerships work. They have worked for over 100 years. They will continue to work. And I'm sure that as long as you plan properly and work around your specific circumstances, it will make sense for you. Don't discount other business structures. Many partnerships will have a joint arrangement where there is, for instance, a service company. Maybe the service company employs staff, maybe it holds machinery, and the two entities, ultimately owned by the same people, work together. But often it's the partnership that drives that. And I don't want you to think that because things can go so horribly wrong with a partnership, they should just be avoided. Just make sure, as I say in the next point, you know where everything is, you know what the assets are, you know what partner is entitled to what, and you make clear that there's not going to be any misunderstandings as far as you can. And that speaks to having those full discussions with the other partners, speaks about having discussions with successors and the next generation and where the business is going to go, because it doesn't necessarily just stop with you and the immediate partners. It might be that you want to carry it forth for generations. And don't forget, there is a whole range of professionals who've been dealing with this for years and years and years, who've seen many instances of where these things have come unstuck and where they've gone really well. And take advantage of that, because this is a tricky area. And there are a number of considerations that the layperson won't necessarily have encountered, because why would you? It's worth the money. And that, if we go to the final slide, is the end of my talk. But I hope that has been informative. I hope it's hit the notes that you all wanted to hear about. There's an awful lot to talk about with partnerships. And so it's a question of how deep do you want to go? But if you've got any questions, please do put them in the chat and we'll see if we can deal with them.
Well, thank you, Harry, for that, for a very thought-provoking and comprehensive review of partnerships, reminding us of the importance of clearly written agreement. We have to review it regularly and make sure we talk to one another, because many a time we don't. And thirdly, keep good records, because I'm terrible at writing things down, but I think I need to make sure I've got that sorted. And I'm sure that Harry's presentation has prompted you to lots of questions. So if you put them in the chat at the bottom of the screen, we'll be able to move on to those in a moment. We'll move into the final part of this evening. This is your chance to ask your questions and share feedback. I'm pleased to invite now the Tenant Farmers Association Chief Executive, Mr. George Dunn, to join us. Many of you will know George well. For those that don't and have been living under a crab or a stone for the last 1,000 years, George has been Chief Executive for the Tenant Farmers Association for nearly 30 years, having previously worked for the Ministry of Agriculture and the Country Land and Business Association, both in London. George served on the Tenancy Reform Industry Group for over 20 years and a member of the ROC Review Group on agriculture tenancies, and continues as a member of the Welsh Government Tenancy Working Group and the Welsh Ministerial Roundtable on the Sustainable Farming Scheme. Outside the TFA, George is a National Trust Specialist Volunteer, a trustee at the Arthur Rank Centre, a fellow, goodness me, it's a long list this, George, a fellow of the Royal Agricultural Societies and on the leadership team of his local church. In 2022, George received the Farmers Weekly Lifetime Achievement Award. In 2023, the British Farming Award for Outstanding Contribution to the Agriculture Industry. And in 2024, an honorary doctorate of law from Harper Adams University. Goodness me, George. So if I can hand over to you now, please, George, that'll be great.
Robert, thank you so much. We must cut down that list the next time we have one of these sessions. I'm going to just try and ask some questions of Harry from the questions that we have had submitted to us in advance of tonight's webinar, and also to intersperse those with some of the questions that are put into the Q&A box tonight by anybody that's on the call tonight. So please do use the Q&A if you've got any questions to put in. So Harry, we're talking about pitfalls here, and let's start with an easy question from one of our members in Gloucestershire. And I think I know what the answer to this question is, having listened to your presentation, but do you need to have a written partnership at all?
So the answer is no, George, as you will be aware, but it would be very advisable to have a written partnership agreement because it gives you the opportunity to make clear what the duties and the rights of all the partners are, and that will give you protection. It gives you the opportunity to restrict some of the more dangerous provisions that will be the default situation of the Partnership Act, and generally gives you the security that you will want in any sensible business.
So we know in our industry, Harry, that an awful lot of things happen on the basis of trust and handshakes. And if you're saying you can have a partnership which isn't in writing, what are the hallmarks of a relationship that isn't in writing that create that partnership? So let's say you had mum, dad, brother, sister farming away together, and something happens in that relationship, and one of them says, "Hang on a minute, I thought we had a partnership here." How do you know you've got a partnership if you haven't written it down?
Well, the answer is not necessarily a straightforward one because it, as I'm afraid many lawyers love to lean on, depends on the facts, depends on the circumstances. And so you might have, for instance, a shared bank account or something like that. But generally, it goes back to that definition of are they all working together to carry on a single trade or business with a view that's to make money. I mean, that is what the test will be, and it will be a matter of do the circumstances around that support or move away from that definition. And it will be quite a comprehensive review that you'll have to look at. It's not as simple as just who's paying the bills, who's making use of the lands. It's everything about that relationship. So it can get quite technical and it can get quite complicated.
So there could be plenty of situations where, in my scenario, mum, dad, and brother and sister working together, all the money goes into the same pot. They all take some drawings out of that pot. That could
Of
be a
course, yeah.
partnership.
And the instances of, for instance, as you say, one single bank account, taking drawings from it, maybe all the expenses are paid from that single account as well, rather than the individuals themselves having separate accounts, paying for their own costs. That would be perhaps even a clearer example of a partnership than you might normally find.
And in that circumstance, Harry, if you had three of the partners who say, "Crikey, we need to get this into writing," and one of them thinks, "Well, maybe we can just carry on regardless." What's the mechanism to get a partnership agreement drawn up between partners who may not agree on every jot and tittle of their business?
It's not necessarily straightforward, is the answer, because you might find yourself in a dispute scenario quite quickly if you can't get that sorted by agreement. You would hope that there can be sensible discussions and you can figure it out and jointly instruct someone to advise the whole lot. It might be that people need to go off and get individual pieces of advice to make sure they understand the extent of their advice of their situation, both now and if they come into some sort of written down agreement, because it could be that you essentially bring an end to whatever the current arrangement is and then formalize a new arrangement. It may be that you're simply adjusting the terms of the current arrangement. It might be otherwise. But if one person doesn't want to agree to any of that, and you might have an existing unwritten partnership, well, that unwritten partnership doesn't just go away. So you might have to effectively go through a rather convoluted and painful process of kicking that first person out, maybe dissolving the whole business, probably, and then making a new one, maybe with or without that person. It won't necessarily be a shortcut unless everyone can sit around a table and hash it out.
So just on that continuing theme, one of our attendees tonight has put in a question. So he and his wife have formed with an unwritten partnership for 30 to 40 years. And they now are thinking about formalizing that to bring in two of their children who wish to carry on the farm business. Where do they start with that?
I'd suggest start at the kitchen table, sit down together and have a frank discussion. Make sure everyone understands what the the hopes are of everyone and see whether you can figure out a sensible mechanism. And it probably will be that if you all agree you want to go into business together and you want to bring that next generation in, that you then want to change from that unwritten partnership to something a bit more formal. And that might be the end of the old business and technically the creation of a new. It might just be a continuation as you bring in new partners. But that's probably something that once you figure out what you want to go and speak to a specialist that deals with business succession, private wealth, property matters, and can give you some comprehensive advice, probably alongside accountants. And that can sound quite pricey, but it will ensure you get a good result, I would hope, and one that future-proofs it.
And I presume in every circumstance, we are looking at very, very bespoke agreements for individual businesses. There's no sort of standard template for this sort of stuff. But members might be aware that we have some headings that people can use to guide the discussion around the issues that they need to think about. So any member that is thinking about forming a partnership or joining a partnership, please ask us for those headings, because that will assist you with your kitchen table discussion. But then I presume, Harry, once we've got that sort of mapped out, it is going to be a solicitor to pull that together into an all singing, all dancing document.
Doesn't have to be, but at least if you do go that way, if something does go wrong, you might have some solicitors' professional indemnity insurance to draw on. So obviously, you hope it doesn't go that way, but you will almost certainly be best advised by getting a sensible agricultural practitioner who knows the nuances of the farming world. And knows how these things work in practice. Not to say you can't do it yourselves, and I'm sure there will be plenty of good resources out there, such as through the TFA. But the layperson doesn't necessarily have the extent of experience dealing with these things that you would normally expect from a capable practitioner in the professional world.
Well, Harry, at that point there's a question here: what clauses in a tenancy agreement might preclude farming through a partnership?
This is a bit of an interesting one, I suppose, because it's very well, I've never seen a partnership, a tenancy which suggests to say that you can't run a partnership or business in this way. Because if it's an agricultural tenancy, there is implicit within that the need to run an agricultural operation, which is presumably a business on the land itself. It seems somewhat neither here nor there. Precisely the shape of that farming operation, though the landlord might get a bit uppity about it. You might have issues with the alienation clauses, I suppose, in relation to how that could come into play if the tenant is effectively holding it on trust for other individuals without the landlord agreeing. You could have a scenario where there's assignment, subletting, which might rub things the wrong way. But a partnership isn't a legal entity in its own right, so that might not necessarily actually be a problem. I think more likely to be an issue is points such as what I think I briefly outlined before, where there might be specific reserved rights that come under the tenancy, which could interfere with the shape of the business that you want to run, or limitations on how you can use the land for putting in new buildings or what have you, if the landlord needs to consent to that and then decides he's never going to consent. Things like that I can see could cause a problem.
Harry, just to tease you out a bit on that. So we regularly see clauses. You refer to them as the alienation clauses in tenancy agreements, or user clauses in the tenancy agreement, where the tenant is often required to be the one who is personally farming the holding, or situations where the tenancy agreement says the tenant is unable to share possession of the holding. And is farming as a partnership a breach of that personally farming the holding as a tenant clause? And would it also be a breach of the clause which says you cannot share possession, because obviously you need to give your partners access to the holding?
The answer is, I suppose it could be. Because by definition, if you've got a partnership, it's more than one person. And if there's more than one person dealing with a tenancy, which is a contract, which says you can only have one person dealing with this, then yes, there could be an issue. like I said, I've not seen that myself, and I would be rather surprised that landlords take issue with that. But I can see where a landlord is a bit nefarious and wants to get the land back and is keen to get rid of the tenant, come what may. Then maybe that's the sort of thing they want to push for. But even then, is that enough to secure forfeiture, surrender, or what have you of the land through whatever mechanism landlord wants to put forward and pressurise on?
But if you're in an AHA tenancy, it could be a notice to remedy situation where you are in breach of
Good.
that particular clause, and that's a a particularly serious potential route that the landlord could take to then serve notice to quit.
Is that something that you've seen, George, out of
Yeah,
interest?
absolutely. On AHA tenancies, we have seen user clauses and alienation clauses which have those words within them, and landlords insist upon them being applied.
Mm. Well, be
And
careful
so
then.
sometimes in county council small holding estates, particularly where you've got very rigid rules and regulations around how those farms are let. So I think that we just need to take a bit of care around that, those alienation and user clauses. Uh, I want to dive into the whole area of the partnership asset issue with the tenancy here, and we've got a question from David Meredith, which I'll come to in a second. So I think you said in your talk, Aaron, correct me if I'm wrong, you said you felt it was something you needed to think very carefully about before you brought a tenancy into a partnership asset situation. But invariably, with a lot of oral agreements and with a lot of agreements which haven't referred to this specifically, the tenancy will fall into the partnership as an asset of the
Mm.
partnership. In what circumstances might you find that if you haven't properly thought about it as an issue, in what circumstances would that tenancy become an asset of the partnership?
The main points that you probably want to look for is who's using the land and who's paying the costs and getting the income from it. If we take perhaps a simpler example of you have a single tenancy bit of land, which is the extent of the land used by a farming business, if you investigate the facts, and it might not be a written partnership agreement or otherwise, but if you find that actually the partnership's been paying the rent, the partnership's been paying whatever costs are associated with the land, all of the proceeds of the profits grown, the crops grown, the profits generated from that paid into that account, then there could be an argument that it is one. And you might also see, and one of the first things I'll check in these sort of circumstances are the accounts. Is the tenancy listed within, for instance, the balance sheet? That would be pretty good evidence that it actually was intended that the tenancy is a partnership asset. So it's a question of the facts. How are they using it? Who's using it? And does that fall into the usual course of business as if it were a partnership asset, or doesn't it? And it may be a bit of a question mark. You might not have a clear answer for it. And I think just having a look at that question, sorry, George, I know you're just about to
All right.
add on to that. The question added how you might hold a tenancy outside of a partnership
Correct. Yeah.
while still using it. And it's a very good question, that, because especially when we're talking about potential dangers of bringing a tenancy into the partnership, which I say dangers, it could be what you want to do. But you can have it quite easily documented within the partnership agreement. For instance, you could have a quite clear clause saying partnership is going to have the use of this land, but it's not going to be a partnership asset. You don't list it anywhere. The tenants themselves might pay the rent. You might have some provision within the partnership agreement that deals with the tenant having some credit towards the rent or what have you, or how there might be the question of liabilities dealt with. It's something that you would want to make sure is carefully considered in the drafting process for the partnership agreement. If you don't pick up the question, you could have a slight problem within that.
So in those circumstances where the tenancy is held outside of the assets of the partnership, but where there's an agreement between the tenant and the partners for the use of that tenancy, what happens if the tenant, for whatever reason, loses access to that land and the partnership no longer has access to it? Is that a breach of the partnership agreement, or particularly if it's something which maybe the tenant has had no control over because it's a development that the landlord has come forward with, and the land is lost due to a case B notice to quit. How does that play if it's outside the scope of the partnership?
Well, it's a question that will probably be answered by what does the partnership agreement say, and if it's silent on the points, then it's a bit unclear. You could have an argument to say that the tenants acted in breach by not properly protecting it, but if it's not a partnership asset and the partner's never intended to be a partnership asset, it might be inferred that, well, that's just a change in circumstances and the partnership just needs to adapt. It will be probably a question of a breach of duty, I would have thought, if anything, because for those on the webinar, partners owe each other what we call a fiduciary duty or a set of fiduciary duties, which essentially they're going to do everything to support the interests of the partnership. And if they don't do that by protecting something the partnership's relying on, you could have an issue there. There could be a claim arising from that.
So, I mean, just playing this through a little bit. So, if you have a tenancy held outside of the partnership asset list, but the tenant gives the partners the right to use the tenancy for the purposes of the partnership business and holds that tenancy will be available to them to do that. And for whatever reason beyond the tenant's control, the tenancy is lost due to the landlord, as I say, having development. If it's not clear within the partnership agreement, could it be that the tenant has got to go and find alternative land for the partnership to use in those circumstances? Or is he or she given a free pass on that because the land was taken away beyond their control?
Well, if they've done nothing wrong, what have they breached? Is the immediate thought that springs to mind. I mean, there is a question of have they breached a contractual provision, possibly, and there might be remedies that flow from that. But as to the duty, if they've done absolutely nothing wrong, there might not be a claim there. So it's a question of how much can you read into the partnership agreement and the remedies that flow for the other partners to resolve the situation for a breach of a contractual claim, a breach of a contract.
Okay, so one more question on partnership assets and tenancies before we move on to other things. So you have a partnership arrangement. There is an agricultural tenancy. The tenancy is an asset of the partnership, and one of the partners decides to leave, and there are provisions within the partnership agreement to allow that partner to leave. But that partner who leaves is the tenant. So the tenant who is the departing partner, what ongoing responsibility does that partner have if they have the right to leave the partnership? What continuing responsibility do they have for the tenancy to be made available to the remaining partners?
And this tenancy is a partnership asset in this scenario.
Correct. Yeah.
So it goes back to how you deal with assets generally, because when somebody leaves the partnership, depending on what the partnership agreement says, they will presumably have a share. It might be nil, but they will have a share to the capital and whatever undrawn profits they might have, the current account. When they leave, there will need to be a accounting of what their share is. And that will take into account, one would think, the value of a tenancy, which you can't necessarily sell. And so the way that the other partners would get their share, as it were, will probably be the outgoing tenant having to pay them a proportion of the value of the tenancy, which they can't otherwise deal with. This goes back to why I was urging some caution before, because agricultural tenancies in particular can be very valuable.
But it could be that the tenant has to leave the tenancy as to be utilized by the partnership, even though they're out with the partnership themselves at that point. If the tenancy is a partnership asset and remains a partnership asset even after the removal of one of the partners.
Well, this is a very technical question. How would that work in practice? Because if you can't assign it, you can't give it to the other partners. The landlord might not be willing to do that. So what do you do then? The answer is surely that the tenant has to continue holding the assets, and
or
they'll have
dissolve the partnership. Yeah. Okay.
which is messy.
Well, follow on from that one with a question just come in, and how do you value a farm tenancy in that
Well,
scenario?
it's a question for a valuer, not a lawyer.
Yeah.
But as I understand it, there is a important case called Greenbank and Pickles, and it considers this topic as well as matters of expert evidence and the like. But the short of it is there's a couple of different ways, but more or less the simple version is you think about how much profit you can make from having that land available over the duration of the life expectancy of whoever. I'm assuming it's an agricultural holdings act tenancy, and you value it that way. You might also deal with it via considering what the difference is between the AHA rent and a market rent. And again, referring back to the life expectancy of the tenant, if they're going to be alive for say 20 years on a expected life basis, and over the course of those 20 years, they're going to save £10,000 by the difference of the AHA rent and an FBT rent, then maybe it's worth 20 years of £10,000, £200,000. That would be one way, but you'd have to go to a valuer, and that's their world.
Well, thank you for that.
Okay, here's a question from a member in Hampshire. So he's got two arrangements going on here. So he's a sole trader in respect of the agricultural tenanted land that he has got, but he currently also farms in partnership on land that he owns with his wife, and he's been considering merging the two to form one trading partnership for both. Is that something he can do and bring the AHA tenancy into that arrangement?
Depends on the tenancy agreement. If there's, for instance, these provisions that you were highlighting before, I suppose there could be an issue there. It sounds like it could be a sensible operation if it makes sense for him and his circumstances and his wife's circumstances. There is no immediate reason on that information why he couldn't do that and necessarily why he shouldn't do it. It's just a matter of checking that the terms of the tenancy doesn't preclude that or cause particular issues, I suppose. And indeed, there could be sound reasons for wanting to do that, because it might mean that the wife, for instance, if there's a succession, has a good chance or a greater chance of meeting the criteria for then succeeding to that agricultural tenancy. Or indeed, if there's a next generation coming along, there's children, they could be brought in and they might also benefit.
Okay, let's dive into the whole area of the responsibility of the partners to each other, which I think you referred to as fiduciary duty. So everybody needs to work together for the mutual benefit of the partnership. What might a breach of that fiduciary duty look like in practice if the partners were in dispute? What sort of areas have you seen in your practice where partners have not followed the rules around fiduciary duty?
Well, a classic one is competing with the business, running their own business, not telling the other partners about it. If you imagine you've got a partner who's got a duty to devote proper time and attention to the partnership, all of a sudden they're spending all their time elsewhere, but still expecting to draw full profits or otherwise. But as a result of them not devoting the time and effort, the business is failing. Well, you could have an issue there. And if they're running another business effectively at the cost of the other partners and who haven't consented to it, they will have to account for the profits that they're earning, particularly if they're using partnership assets. So you can have a variety of different claims here. There's a range of relief available where there has been a breach of fiduciary duty. It could be damages, could be compensation, it could be injunctive relief to force them to stop doing a thing or to make them do a thing. It's really the sky's the limit, because equitable claims are quite creative in many ways. But that's one that I do see quite commonly, where there's a falling out. Somebody might just decide to stop spending time with the business and go do their own thing and damn the consequences.
So here's a good segue into a question that's been raised by one of our members in Lancashire, who they're operating within a partnership. but the partner has one of the partners is using a farmyard for another company that they're involved with, making a profit on the use of that farmyard outside the scope of the partnership, even though that's a partnership asset, and none of that's been disclosed or agreed with the other partners. Is that a breach of fiduciary duty, and would that be grounds for expulsion?
Uh, Short answer is it sounds like it probably is a breach. You'll need to check what the terms of the agreement are. Maybe it permits them to do that, but I would be quite surprised if it does, especially if he's doing it without getting the consent of the other partners first. Because what these agreements often say is you're not allowed to do that unless all the other partners consent in writing first, and then you're okay. But if he's just gone and done it, absent any provision otherwise, and particularly if he's using what I assume is a partnership asset in the farmyard itself, then we're back to that scenario of profiting off the use of partnership assets without accounting for the same to the partners, and that will be a breach. As to whether it's expulsion as the route, as opposed to, for instance, damages equivalent to the profits, that will probably depend on the partnership agreement. It might be that the partnership agreement permits expulsion in such a scenario. It might be that the partnership agreement permits expulsion if all the other partners simply decide that they want to expel someone, as they often do. So it would be a matter of checking the agreement and then advising. But it sounds like that person's on a bit of a rocky footing there.
Okay, well, let's just deal with two more quick questions that have come in tonight before I hand formally back to Robert to conclude. So, Laura has asked a question around share farming agreements, which are another type of way in which you can farm together. And she says, obviously, in those agreements, there's no intention to create a partnership. And is that contracting out statement sufficient to protect those in a share farming agreement from others trying to claim commodities as a sort of partnership asset way? So is that ability to say we are not creating a partnership sufficient to not have a partnership, if you know what I mean?
Yeah, the answer is it probably will be.
Yeah.
I mean, you might have a peculiar case where it doesn't do the trick, but I would be very surprised if everyone's declaring when they're going into this, presumably in share farming agreement, which is a contract, that they're not creating a partnership. It'd be rather perverse for them to go back and say that they actually have created a partnership. And indeed, if somebody were to try and bring a claim where they're asking a court to find that, the first thing someone like me would do when you have a contract where they say they're not going to do that is you show it to the judge and say, hold on, you can't go back on your word that way. What's going on here? So I wouldn't be too concerned as if that does not do the trick of preventing a partnership coming into being.
I think the phrase is you've got to have clean hands before the law, isn't it? Something along those lines.
It's one of the Exwell maxims, yes, but
Yeah.
that's a rather particular one. But yes,
Yeah. Okay, and finally then, Harry, we've kept you long enough tonight, so before I hand back to Robert, we have a question here from someone who's on the call tonight. So there's an informal partnership, partially written. It's an agreement between father, mother, and son in this instance. They are looking at the potential scenario of a future daughter-in-law coming onto the scene who wouldn't necessarily be included as a partner in the business, but they're concerned about what might happen if that relationship between the son
Mm.
and the daughter-in-law came to an end. And would the daughter-in-law have a call on some or all of the partnership assets, given the marital situation with her with the son in that circumstance?
Well, this is the sort of scenario that unfortunately does sometimes cause real issues within partnership businesses when a newcomer comes in and upsets the status quo for whatever reason, rightly or wrongly. Um, this moves into the remit of family law, which again, qualifier, not my area. But family divorces and the like, when you come into that, which I think is probably the concern behind this, yes, the spouse can often have a claim for a good chunk of the other spouse's assets, and if the other spouse's assets includes a share of a partnership business, then that can be a concern. It absolutely can. It won't necessarily be in particular assets, but it might be the value. And if you then need to have a scenario where they're essentially being bought out, obviously that can be quite pricey, because in a farming world, you might not have a huge amount of cash, but you may well have a good amount of machinery, kit, land that's worth a pretty penny, and so these shares can be quite valuable. I'm not saying you can't deal with that scenario, and you should just never let your children wed or anything like that. But you might want to speak to a family practitioner, or encourage them to speak, and encourage a prenup agreement, a prenuptial agreement, which can deal with those sorts of scenarios, and say that if the relationship does end, these sorts of things won't be affected, and they know that when they're going into it. So you can structure things that way, and indeed you might want to deal with that in the actual partnership documentation separately to try and bring some protection there as well, to the extent possible. But if the spouses share the partnership, there is danger, and you should think about that. So it's a sensible question.
Thank you, Robert. Control is yours.
Thank you, George. Well, I think that's quite a good point to bring conclusion to our evening. Firstly, I'd like to thank Harry Russell and George Dunn for an excellent evening, and to Roythornes Solicitors for their sponsorship. Our next webinar takes place on the Tuesday, the 2nd of June, when we'll hear how the National Trust is engaging with its tenant farmers to deliver strategy for people and nature to thrive. Senior Trust representatives Giles Hunt and Richard Wielden will be joining us. As always, it's free to attend, and it starts at 7 p.m. and runs for an hour, includes the live question and answers. You can register via the TFA event area on tfa.org.uk. We hope that you found this evening's webinar useful. Thank you for attending, and we hope that you will join again with us soon. Good night.